Hello friends, welcome back to my channel. Today we're going to give you an update on my most recent traffic trial. It began on October 29th of 25. It was not completed because, as you know, Judge Larry J. Blake Jr., biased and corrupt as hell individual, I gave him a nickname, Baby Boy. That's what he's gonna go by from now on. Every time I'm going to refer to him, this is gonna be the Baby Boy. This Baby Boy judge of the Municipal Court for the city of Happy Valley has such a fragile ego. He got offended because I called out his judicial misconduct because he was representing the state rather than being an impartial judge. So I'm gonna give you some facts about the case, lay some groundwork, play a couple of audio recordings. So this time I was able to record on my subsequent December 3rd hearing. He finally, well, he should have allowed me to video record, but he got a little scared, and I'll get to that in a minute. So he only allowed me to audio record, just like last time, but I wasn't able to. I didn't have the right equipment with me, obviously. But this time I brought the equipment. So, very nice. So, at least I was able to set up my phone to properly record it so we can at least hear some audio of it. Now, as you remember, this traffic stop is related and stemmed from the unlawful retaliatory traffic stop where I was actually just now finishing my investigatory reporting on the city of Happy Valley, and I just left the police station, and literally not even a block or two from the station I am being pulled over for allegedly driving on a suspended driver's license. Now, I've never interacted with Marshnikov before, other than I saw him in court and called him out on something unrelated. And he never had my identification in his hand, never knew my name. How he got it is still a mystery. So, during the traffic stop, my vehicle was impounded and I was cited for allegedly driving while suspended. That's not the same thing that he put in his complaint. And cited for allegedly not having proof of insurance, but again, he never verified that. So, you know, that's fine. Now, we're gonna get to trial. On the first trial on October 29th, it was clearly a setup. Just give you briefly. I'm the only defendant. They didn't allow me to go in the courtroom until I was called in, even though it was open, but it was empty. I'm the only defendant. Imagine this, really. The only defendant scheduled for the day. Now, granted, sometimes it happens. But in this particular municipality, the number of citations that are written, I was the special occasion. And it was a setup. I already knew that. The moment I walked in, I knew that. That's alright. Let the judge dig his own hole. Now, fast forward. December 3rd. December 3rd, my continuing trial. It was a set-over. Again, I was not allowed into the courtroom until I was called. Now, as I'm getting called, I'm the only individual targeted. My property is unlawfully searched in violation of my Fourth Amendment right and the articles of the Oregon Constitution. I'm the only person. They searched all of my belongings, my person, my bags, my clothes bags, went through my documents, everything. Only then I was going to be allowed. And if I wasn't going to willingly submit to that, or even allow it, I was not going to be allowed to be present in the courtroom. In other words, my due process was completely denied. Now, of course, I objected to that search. I did not consent to that search. They went and did it anyway, and my trial proceeded. Listen, I have no problem, absolutely no problem, of them digging their own hole. And if City of Happy Valley has millions of dollars extra to settle the lawsuits that are coming, so be it. So folks, I might give you a little bit of a closing video at the end of my speech, but now let's just jump into it and let me show you exactly what took place. It's going to be very much edited out. The entire trial took 1 hour, almost an hour. I got 55 minutes of audio recording, but I'm just gonna show you bits and pieces that are really important. And let me just point it out for you. The level of corruption in that municipality is off the charts. I was ultimately found guilty on both charges. Now, the driving while suspended is the sole and the only moving violation that the state deputy Alex Marzhnikov alleged. But in the complaint, he included the violation in the statute that does not exist in law. And despite this judge factually looking and examining the complaint, absolutely dismissed that fact and found me guilty. Just pay attention to this, guys. Found me guilty on a statute of a violation that does not exist in law. Well, Judge Blake Larry, your last name Blake, Larry, Junior, baby boy, biased, corrupt as hell, whatever you want to go by. Do you understand how motivated I am now to really F up your career? Do you honestly think that when my appeal is going to be filed, that you will survive it? How about when I start filing complaints with the Oregon State Bar? You are going to lose your license, your judicial career, as well as your private attorney practice is over. And you are experiencing the last days of your corruption, the last days of your reign of evil. I'm going to bring that to the end for you. In the name of my God, Lord Jesus Christ. You should have never screwed with my God and me. I'll see you around.
How do you like violating people's rights? Feel good about yourself? Huh? Simpkins, you feel good about yourself? You're just doing your job, right? Like Nazis? No, you are a Nazi. You're a tyrant. You saw exactly the injustice, the violation of constitutional rights. And you said nothing. You're a traitor. All of you traitors. Did nothing, absolutely nothing, like a Nazi. You know you're gonna be answering it not just to me, not just the state. You're gonna be answering this to God.
I come in there and I did not disobey you. When you told me to be here, I'm here. When you told me the tickets were there, I went to automatic. I came right and talked to you. $530,000 fine is bullshit. That's not even, that's crazy. That's insane. I'm fucking working there. We're not.
Just goes
I'm gonna chase you out here. What? What do you got? You got to run the camera?
I brought a camera.
Yeah, run the camera.
And for your safety too, by the
For
way.
my safety?
Yeah, for your record.
I appreciate that.
You might want to go move your motorcycle from improperly parked there, Marshnikov. That's Marshnikov. Go record him. Go record him outside. He ran away. It's okay. Don't worry about it. Coward. Yeah. We'll see him in a little bit. Huh? No. He's just pretending like he didn't park over there. He's just pretending. Okay, very nice. Thank you.
Any other questions before we continue with the trial?
I think for now, I think we're gonna cover it. So if I do have another question, if you would mind, I would just ask you that I do have a subsequent question.
That would be great. So we'll start the trial again. Again, we left off with you questioning the officer. And again, the only other caution I have is to make sure that any questions you have are relevant to the charges at hand. And the two charges that you have here today are driving while suspended and driving uninsured. Any other questions, unless they're somehow causally related to the issue at hand, will not be a proper question. So go ahead and ask your next question.
Yes.
Go ahead.
Okay. Deputy Marshnikov, I just received a copy from the court of Exhibit 1. Is this the exhibit that you filed?
No, it's a copy of it.
Okay, so you acknowledge this is a true copy of it. My question to you, the original did not come in this form or format, correct?
I'm confused.
Let me rephrase my question. When you submitted your exhibit, state's exhibit, as the plaintiff, you submitted it folded up like a trifold in the envelope, and it was not marked as plaintiff exhibits, correct?
So what you're getting is you're getting a photocopy of what I submitted to the court as an exhibit.
Correct, that's a photocopy. But what I'm saying, it did not come originally in this form or format.
That is a copy, so that would be a different form, yes.
One of my objections was to this court in objection of admitting this exhibit into the record was that it was not in fact labeled or marked as exhibit at all. And we can only see there's only one page so far that I can view is only marked as exhibit number 1. So it didn't come as this original format or form, is that correct?
Clarification, the court on plans exhibit number 1.
Okay.
So ask another question.
So my question then has been answered by the court. Why did you submit this exhibit?
Because that's part of trial, that's stuff in court.
What is the purpose or the evidence that the court should look into this exhibit? What is it supposed to
It
prove?
shows that DMV suspended your driving privileges, and that is a letter from DMV stating that what I allege happened actually did happen.
On what page does that state that of this exhibit?
Just read through it and you can find that information on there.
Deputy, on what page does it state that? You don't know. Did you personally request this
I did.
exhibit? Through whom?
Through county records.
Amanda Castro, that is actually listed here as the recipient of this record. Who's Amanda Castro?
That is a Clackamas County Sheriff's Office employee.
So if you personally requested this, why would it be then addressed and directed to Amanda Castro?
Because records come back to Clackamas County Sheriff's Office Records Division, and then they distribute it to whoever it needs to go to, so then they forward it to me.
So just to clarify, you were not directly in contact with the Department of Transportation. You were actually requesting this information through a third party.
Correct.
Okay. And did you review any content of this exhibit when you admitted it into record for the court to review?
I did.
And what did you find?
That your driving privileges were suspended at the time that you were stopped.
Can you tell me the date that this was sent to you?
It should be on there. You have a copy, I don't.
On there where? What page am I supposed to be looking at?
I don't know.
Do you have a copy of this exhibit?
I do not.
And why did you not retain a copy for yourself?
But I want to.
Interesting. So I'm looking at it and it says date issued August 18th of 2025. Is that correct?
If that's what it says, then that's correct.
Okay, so you acknowledge that. And that is subsequent to the traffic violation which has occurred on August 7th, is that correct?
That's correct.
That's correct. So you didn't have any knowledge of this document or the content of this document at the time of the traffic violation, alleged traffic violation.
I had knowledge that you were suspended. This is just confirmation that is true.
And how did you acquire that knowledge?
Through systems available to me as a deputy sheriff.
On what date?
The date that I stopped you.
The date that you stopped me, you acquired knowledge.
I knew that you were suspended, correct?
How did you know that?
Because I looked into your name and I knew that you were suspended, and when I saw you driving, I stopped you, knowing that you're suspended, and then as a result, issued a citation to your car.
Okay, okay, interesting. Let's,
Police works.
so you, okay. All right. That's interesting, very interesting. Now, have you ever stopped me prior to August 7th on any traffic violation?
No. I would have never hold it, no.
So you never stopped me personally?
Not until August 7th.
Okay. And have you ever had any interaction with me prior to August 7th where you would examine my government-issued identification?
I've never had any legal reason to stop you, so I never asked you for any ID before, so.
So just to clarify again, you've never had any interaction with me where you would actually come into physical contact with my government-issued
I've
identification?
interacted with you before, but I've never stopped you, and therefore I never asked you for any of your information.
How did you interact with me before?
You gotta make sure that he finishes his answer before you interrupt him, so make sure he finishes his answer before you start another question.
Acknowledged. Acknowledge it. Go ahead, if you're not finished.
So I'm going to wrap this up to the relevance of you driving while suspended and you driving uninsured. So let's narrow the questioning down to that, because we're kind of starting to go off on a tangent. Has nothing to do with the fact that you were driving a vehicle, you did not have valid driving privileges in the state of Oregon, you were stopped for that violation, you were issued a citation, and this is why we're here, right? At the time, you also refused to provide proof of insurance. That's why we're here. So, again, you're starting to go off on a tangent, so let's ask your question again.
Just go ahead and ask another question, sir.
I'm establishing probable cause, and the reason I'm asking some of the precluding questions is to establish probable cause, which you stated on record that the probable cause was for allegedly driving while suspended. Is that correct?
I'm not allegedly, but driving while suspended.
Wait a minute. So what we've done already is that number one has already been admitted. There is no issue about probable cause for the stop because there is no motion to suppress. So now we just ask questions about the driving while suspended and the driving uninsured. The issue of probable cause was not raised and therefore not litigated. So ask a question about the driving while suspended or driving uninsured.
You are correct, Judge. The issue of probable cause was not raised because we haven't had the opportunity to actually raise that issue because the court proceedings were interrupted. So that's why right now we are raising that issue because I didn't have the opportunity to do so.
Well, it should have been raised before the trial by a motion to suppress. We didn't do that. So now we're going to deal with the two charges. So ask a question about driving while suspended or driving uninsured. Go ahead.
Well, the actual issue here is the probable cause of the deputy knowing my name. So how could the deputy know my name if the deputy never interacted with me, if deputy never had an opportunity to actually examine my identification? How could a deputy know which vehicle would I be driving allegedly or traveling in as a private person? Could you start playing your beginning of your video, please, for me? Because I want to introduce that as evidence. Judge, I'm going to introduce to you case law that specifically addresses the issue that we are trying to ascertain here and establish. I do believe as a defendant I have the right. The state here cannot affirmatively.
Are you done with your questions of the deputy? If we have argument, we'll go argument.
Well,
but we'll have to be finished with questions first.
if I may, Judge, I'm not being given the leeway to actually get my answer or my question answered. So it is obvious now that the state had no evidence to present to this court that they had prior knowledge of the name, identifiable features of the defendant. In this case, it would be me, the vehicle, or otherwise. The exhibit that was pulled as a record was not done on either August 7th or prior to. Therefore, the stop itself appears, and it is, unlawful. So, Deputy, my question is, after you stopped me and you requested my driver's license, was it produced?
No.
So when you were running the DMV records, what name did you put into that record? Whose name?
Your name.
Why did you know that Leonid Krivolenkov is my name?
Well, let's just say that if I didn't know who you were and I made a traffic stop that I believed to be a lawful traffic stop and had probable cause, and you failed to produce your identification, and I didn't know who you were, I would have taken you out of the car, I would have handcuffed you, and I would have transported you to jail for failure to carry equal percent, which is a crime, right? That did not happen because I knew who you were. So I hope that answers your question.
Again, can you articulate how you came into the contact, any facts of the name Leonid Krivolenkov, which you also put on your complaint? How did you come into contact with that name?
Again, we're not going to answer questions about the reason for the stop because that we've already established and exhibit number 1 has been received. So again, ask questions relevant to the question.
Okay. So even during the traffic stop, you did not have in your possession any identifiable government-issued identification with the name of Leonid Krivolenkov. Is that correct?
Nothing produced from you. I did have confirmation that I was talking to you on my end, and I knew exactly who I was talking to.
How did you establish that you knew exactly who you were talking to?
Well, he's already testified that he brought up your driving record and photo, as I recall. Is that correct?
Correct.
Okay. Ask another question.
And you didn't arrest me for failure to produce identification,
Because I knew you were.
but you are testifying here that I have allegedly committed that crime.
What crime are you talking about?
Failure to produce a driver's license.
Well, he did produce a license according to the deputy, but he decided not to arrest you because he knew your identity. Is that a correct presentation?
That is correct, yes.
Okay, ask another question.
But just I want to clarify, but you are accusing me of that crime? Is that my understanding?
He's not accusing you of the crime. Again, we're getting off topic. It's the driving while suspended, driving uninsured. Ask questions about that.
Okay. Did you issue a citation in that in this case?
I did.
And did you file a complaint with this court?
That would be a citation, yes. It gets forwarded to this court.
When did you file that complaint?
Let's see, it was on August 7th.
On August 7th.
And by end of the day, that was submitted, and then it gets processed. I don't think that's out of my control. I don't know how.
And which method did you use to submit the complaint?
Electronic.
Electronic. And did you retain a copy for the records of your department?
It's digitally stored.
Okay. And the allegation of drive while suspended, that is your allegation? That you stopped me for?
I cited you under ORS 11175.
Okay. And that was the only or the sole moving violation for the stop, correct?
That's correct.
That's correct. I want to introduce Exhibit 3. And this is your complaint. And in the offenses, can you tell me what you have listed in offense number 1?
Driver while revoked violation.
But that is not consistent with what you've been testifying here, driving while suspended. That's a different.
If you look at ORS 11175, it'll say driver while suspended or revoked/revoked. So it's the same statute.
Okay. Can you tell me exactly how you have listed that statute in your complaint?
I don't understand the question. You asked me.
Real simple. Can you tell me how you have classified the offense, or what statute did you list in the complaint as the offense number 1, Deputy?
11175.
The way I'm reading it is 811.1751R, driving while revoked/violations. Can you tell me what that statute is?
So 81175 is violation driving while suspended or revoked. That's the statute.
I would not disagree with you, but that was not my question. My question was to you, can you state to me, quote to me, specifically how you have listed the alleged violation in the complaint that you have filed on August 7th as offense number 1 as your sole allegation or probable cause or the reason for the stop in the complaint itself?
It's okay. You must not understand how the system works. I'll explain that to you. So when I fill out a citation in Report Me, which is the program that we use that generates this Oregon uniform citation and complaint, and in there, when I select the driving while suspended statute, I just double click on that, and it auto-populates everything you see on that citation, right, including the baseline. So I hope that explains how what you're looking at and why it says that, and it's also partially abbreviated because there's not enough room to fit everything, so not everything is articulated. But what is it is 81175.
So we agree, and you agree, that the statute that you have listed specifically in the complaint, which is a legal document, and it is presented into court, and we have to follow certain procedures and rules and formats, because if we just go ahead and just put whatever information on here, right, because you certified here, it has to be by law, it has to have specific standard, and it has to specifically list the proper allegation, and you agree that what you have included here as a typed out 811.1751R does not exist in law. I've asked your question, Deputy. If you want to take a little bit more time and answer that
So
question.
what's the question? Repeat the question.
I'm going to try to repeat the question, Judge, but I'll probably simplify it. Deputy, you would agree that we have to follow certain procedures, guidelines, that our legislator has put in fact as to how a complaint has to be submitted into court, because the allegation has to be truthful and accurate. And you certified under the penalty of law for false certification that the information containing in the complaint is accurate. So you would agree, and the court would agree, that as it is typed out in the complaint as the offense number 1, which is the probable cause or the reason for the stop, and the allegation against me as the defendant in this case, that 811.1751R does not exist in law in the state of Oregon. Is that correct?
Go ahead and answer the question if you can.
Again, ORS 811.175 is the ORS that we use that describe violation of driving while suspended or revoked. I don't work for the IT department. I don't get to decide how that gets entered when it's auto-populated. But that is the statute that is selected. That is how it gets submitted to the court. So, that being said, we were issued a citation for violation of ORS 811.175 for driving while suspended.
Deputy, I'm going to present to you, this is the exhibit that was submitted. Do you see your signature there?
Yes.
And is that your signature?
Yes.
And is that the complaint you submitted?
That's correct.
And is it not your responsibility to make sure that the complaint you filed, certified under the penalty of law, that is accurate and truthful?
I believe it's accurate and truthful.
You believe it's accurate and truthful?
I know 100% it is.
So you agree with everything that is on this complaint is to, 1, you acknowledge, and that is your knowledge, correct?
I agree with everything that's on that citation.
Okay, great. Is it your IT's responsibility to sign the complaint? Or is it your responsibility to make sure when you put your signature on it and you certify under the penalty of law for false certification that the information you are submitting in this court as a legal document accusing a defendant of violating a specific offense and statute, that the information you are submitting to the court is accurate and truthful? Is that correct?
That's correct.
That is your responsibility, correct?
That is correct.
Again, I'm going to ask this question for one last time. Does statute that you have included as the offense number 1, specifically typed out in the complaint as 811.1751R, you agree it does not exist in law?
You've already asked that question. Ask another question.
So we agree that it does not exist in law, correct?
Ask another question. You've already asked that question. Ask another question, sir.
I will simply make the motion, Judge, that based on the evidence and the testimony of the state, the defendant moves to dismiss this case entirely because the statute in offense number 1, driving while revoked or suspended violation, as it is written and typed out in the complaint, 811.1751R does not exist in law. The reason we did need to address the second non-moving violation is because this traffic stop was unlawful. The state could not prove exactly how the state acquired my name, therefore the state had no idea who was actually operating a motor vehicle. In my closing argument, I will introduce a case law specifically addressing that issue, and that would be State versus Panko. And this is a case from an appellate court, a decision in 1990, which actually talks about the lawfulness of stopping someone. And I quote from the case: a peace officer who has probable cause to believe that the registered owner of the vehicle he sees being driven on a public roadway has a suspended driver's license, has reason to believe that the driver is committing an offense of driving while suspended,
therefore he would be justified in stopping the vehicle. Unless, of course, the driver's observable characteristics, such as sex, age, or other circumstances, put the officer on notice that the driver is not the vehicle owner. And in this case, the state could not tell who was operating the vehicle. The vehicle was driving. There was no traffic violations. The officer did not have any prior name of the individual driver who was operating the motor vehicle. They didn't even have any identifiable identification to verify who's the driver or whose information should be put in the system, because he clearly didn't have the name. Second of all, observable characteristics could not have been viewed from the viewpoint of the officer, from where he was. Oh, by the way, you were committing a violation of traffic stop yourself while you were unlawfully operating a motor vehicle on the sidewalk. And yes, a complaint has been filed against you in that case. So, from his vantage point, he could not tell. The vehicle itself, we know from the record, had tinted windows. We also know that the deputy was wearing his helmet, which also has a shield, which is tinted, and he was wearing sunglasses. We know that as well from the record that has already been examined. So how could he see or be able to say exactly who's the operator? Is it male? Is it female? The age? Well, he didn't even have the name. So how could he even know what to put into the record in the 30 seconds or less that he had the ability to see the vehicle that he testified had prior knowledge? Well, he didn't even run it until August 18th. And whatever he's testifying that he ran on the site, on the spot, whose name did he put in? Well, let's see. Earlier, we know from the previous testimony, the state also testified that I have a valid Washington State driver's license. Let's take a look at the complaint. Well, whose information is on this complaint? Well, I see, let's see, identifiable information about the defendant. Well, we have the name of Leonid Kryvolenko. We don't know for a fact that defendant actually goes by this name. At least he didn't have that information at the time of the traffic stop. Race, sex, he couldn't tell that. White, he didn't know that. Height, not listed. Hair brown, I don't have brown hair. Eyes, nothing's listed. License expiration, nothing listed. Classification, NO. Let's see. Do we even have an identification number? Oh, ID type, DL, number 6027970, State of Oregon. Whose driver's license is that? We heard a testimony that he never had my driver's license in his possession. Interesting. So whose information is this? I have no clue. He doesn't have a clue. Nobody can tell me whose information this is. We have my address here. Sure, I'll acknowledge that. That's easy to put in. You can Google my address. But other identifiable information? Can I ask a question now in my closing statement, Judge? Okay, great. So, again, if the court can acknowledge that this particular complaint, as I have already stated, is flawed with so many improper data in here, and the officer certified to that data to be accurate and true, I say the officer is walking into a crime of false certification, and that is a misdemeanor crime. In fact, it's such a level of a crime when it's committed in my presence, under the authority of the state laws, I can place you under arrest as a private citizen, under citizen's arrest. In fact, the state law authorizes me to use force in effectuating that arrest. In fact, that authority extends to me as far as using deadly force when necessary in self-defense. So I say, and I make my argument, that the state did not prove its case. The state submitted a flawed, faulty complaint, never made any attempts to rectify any of this information that is way beyond any bounds of law. In fact, offense number 1, which is a moving violation, driving uninsured, is a non-moving violation. So unless the state has any evidence to establish that in fact this traffic stop was lawful, the argument is simple. Any evidence that the state discovered of any other non-moving violations is all fruits of poisonous tree. and cannot be admitted into the record and cannot be charged here. And specifically, the first offense is the governing offense, and therefore, how could there be any violation of any law, of any proceeding in this court? And I gotta, Judge, if I may state bluntly, you do realize that this would be appealed immediately, and the circuit court is going to look at it and throw this case right out. I mean, I don't want this to be on your record, so I'm simply asking you, do the honorable thing and dismiss this before it gets really, really improper for this entire court. And that is all that I should say.
Well, thank you very much for considering my status in this, and I appreciate that. I'll make a finding that you're in violation of both statutes, driving while suspended and driving uninsured.